Your Honor, ladies and gentlemen of the jury, the defense will rest.
All right. State of Texas.
Stay closed.
Defense also closes, Your Honor.
All right. So, ladies and gentlemen, we have come to this moment in the trial where both sides have rested and closed their case. So now you will hear the court's charge, which is the law that you will have to follow during your deliberations. And I remove my mask so y'all can hear me more clearly. Cause number F1875401, styled the state of Texas versus Billy Kipkori Chemirmir. Court's charge. Members of the jury. The defendant, Billy Kipkori Chemirmir, stands charged by indictment with the offense of capital murder alleged to have been committed on or about March 20th, 2018 in Dallas County, Texas. To this charge, the defendant has pleaded not guilty. The following instructions are the law applicable to this case. You are instructed that you may read these instructions as a whole. Offense definitions. A person commits murder if the person intentionally or knowingly causes the death of an individual. A person commits capital murder if the person commits murder as that term is herein defined, and the person intentionally commits the murder in the course of committing or attempting to commit burglary or robbery. A person commits burglary if without the effective consent of the owner, the person enters a habitation and commits or attempts to commit a felony, theft, or an assault. A person commits robbery if in the course of committing theft, as that term is herein defined, and with intent to obtain or maintain control of the property of another, the person intentionally, knowingly, or recklessly causes bodily injury to another. A person commits theft if the person unlawfully appropriates property with intent to deprive the owner of the property. Term definitions. Actor means a person whose criminal responsibility is an issue in a criminal action. Another means a person other than the actor. Appropriate means to acquire or otherwise exercise control over property other than real property. Appropriation of property is unlawful if it is without the owner's effective consent or the property is stolen and the actor appropriates the property knowing it was stolen by another. Attempt to commit an offense occurs if, with specific intent to commit an offense, a person does an act amounting to more than mere preparation that tends but fails to affect the commission of the offense intended. Bodily injury means physical pain, illness, or any impairment of physical condition. Deadly weapon means anything that in the manner or its use or intended use is capable of causing death or serious bodily injury. Deprive means to withhold property from the owner permanently or for so extended a period of time that a major portion of the value or enjoyment of the property is lost to the owner. Effective consent means assent in fact, whether expressed or apparent, and includes consent by a person legally authorized to act for the owner. Consent is not effective if induced by force, threat, or fraud. Felony means an offense so designated by law or punishable by death or confinement in a penitentiary. Habitation means a structure or vehicle that is adapted for the overnight accommodation of persons and includes each separately secured or occupied portion of the structure or vehicle, and each structure appurtenant to or connected with the structure of or vehicle. In the course of committing theft means conduct that occurs in an attempt to commit during the commission or in immediate flight after the attempt or commission of theft. Individual means a human being who is alive. Owner means a person who has title to the property, possession of the property, whether lawful or not, or a greater right to possession of the property than the person charged. Person means individual. Property means tangible or intangible personal property, including anything severed from land or a document, including money that represents or embodies anything of value. Possession means actual care, custody, control, or management of property. Steal means to acquire property or service by theft. Mental state definitions. The following definitions apply to the offense of capital murder. A person acts intentionally or with intent with respect to a result of his conduct when it is his conscious, objective, or desire to cause a result. The following definitions apply to the offenses of burglary, robbery, and theft. A person acts intentionally or with intent with respect to the nature of his conduct or to a result of his conduct when it is his conscious, objective, or desire to engage in the conduct or cause the result. A person acts knowingly or with knowledge with respect to the nature of his conduct or to circumstances surrounding his conduct when he is aware of the nature of his conduct or that the circumstances exist. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. A person acts recklessly or is reckless with respect to circumstances surrounding his conduct or the result of his conduct when he is aware of but consciously disregards a substantial and unjustifiable risk that the circumstances exist or the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the actor's standpoint. Capital murder. Now bearing in mind the foregoing instructions, if you unanimously find from the evidence beyond a reasonable doubt that on or about March 20th, 2018 in Dallas County, Texas, the defendant, Billy Kipkori Chemirmir, did intentionally cause the death of Lou Ty Harris, an individual hereinafter called deceased, by smothering the deceased with a pillow, a deadly weapon, or with hands, a deadly weapon, or with an unknown object, a deadly weapon, the exact nature and description of which is unknown and unknowable to the grand jury, and you further find beyond a reasonable doubt that the defendant was then and there in the course of committing or attempting to commit the offense of burglary of Lou Ty Harris, then you will find the defendant guilty of capital murder as charged in the indictment. Or, if you unanimously find from the evidence beyond a reasonable doubt that on or about March 20th, 2018 in Dallas County, Texas, the defendant, Billy Kipkori Chemirmir, did intentionally cause the death of Lou Ty Harris, an individual hereinafter called deceased, by smothering the deceased with a pillow, a deadly weapon, or with hands, a deadly weapon, or with an unknown object, a deadly weapon, the exact nature and description of which is unknown and unknowable to the grand jury, and you further find beyond a reasonable doubt that the defendant was then and there in the course of committing or attempting to commit the offense of robbery of Lou Ty Harris, then you will find the defendant guilty of capital murder as charged in the indictment. If you do not so believe, or if you have a reasonable doubt thereof, or if you are unable to agree, you will then consider whether the defendant is guilty of the lesser included offense of theft. Now, bearing in mind the foregoing instructions, if you unanimously find from the evidence beyond a reasonable doubt that on or about March 20th, 2018 in Dallas County, Texas, the defendant Billy Kipkori Chemirmir did then and there unlawfully appropriate stolen property, to wit a red jewelry box and jewelry of the value of $750 to $2,500, the said property having been stolen from Lou Ty Harris is unlawful, its lawful owner, and the defendant acquired said property knowing that it was stolen property, then you will find the defendant guilty of the lesser included offense of theft. If you do not so believe, or if you have a reasonable doubt thereof, you will follow the following instructions. If you should find from the evidence beyond a reasonable doubt that the defendant is guilty of the charged offense or of a lesser included offense, but you have reasonable doubt as to which offense he is guilty of, then you should resolve that doubt in the defendant's favor and find the defendant guilty of the lesser offense. It is not necessary for you to acquit the defendant of the greater charge in order to consider a lesser offense contained in the court's charge. If you believe the defendant is not guilty of any offense or have a reasonable doubt thereof, then you will acquit the defendant and say by your verdict not guilty. Presumptions and burden of proof. In all criminal cases, the burden of proof is on the state. All persons are presumed to be innocent, and no person may be convicted of an offense unless Each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant, unless you are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in this case. The state has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. This burden rests upon the state throughout the trial and never shifts to the defendant. If the state fails to meet its burden, you must acquit the defendant. It is not required that the state prove the defendant's guilt beyond all possible doubt. It is required that the state's proof excludes all reasonable doubt concerning the defendant's guilt. In the event that you have a reasonable doubt as to the defendant's guilt after considering all the evidence before you and these instructions, you will acquit the defendant and say by your verdict not guilty. Evidentiary instructions. You are instructed that you are not to allow yourselves to be influenced in any degree whatsoever by what you may think or surmise the opinion of the court to be. The court has no right by any word or any act to indicate any opinion respecting any matter of fact involved in this case, nor to indicate any desire respecting its outcome. The court has not intended to express any opinion upon any matter of fact in this case. And if you have observed anything which you have or may interpret as the court's opinions upon any matter of fact in this case, you must wholly disregard it. At times throughout the trial, the court has been called upon to pass on the question of whether or not certain offered evidence might properly be admitted. Do not be concerned with the reasons for such rulings and draw no inferences from them. Whether offered evidence is admissible is purely a question of law. In admitting evidence to which an objection is made, the court does not determine what weight should be given such evidence, nor does it pass on the credibility of the witness. As to any offer of evidence that has been rejected by the court, you of course must not consider the same. As to any question to which an objection was sustained, you must not conjecture as to what the answer might have been or as to the reason for the objection. You are instructed that you may consider all the relevant facts and circumstances surrounding the alleged killing and the previous relationship existing between the defendant and the deceased, if any, together with all relevant facts and circumstances going to show the condition of the mind of the defendant at the time of the offense alleged in the indictment. You are instructed that if there is any testimony before you in this case regarding the defendant's having committed an offense other than the offense alleged against him in the indictment in the case, you cannot consider that testimony for any purpose unless you find and believe beyond a reasonable doubt that the defendant committed such other offense, if any was committed. And even then, you may only consider it in determining the motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident, if any, and for no other purpose. You are instructed that the defendant may testify in his own behalf if he chooses to do so. But if he elects not to do so, that fact cannot be taken by you as a circumstance against him or prejudice him in any way. The defendant has elected not to testify, and you are instructed that you cannot and must not refer to or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever. Concluding instructions. It is only from the witness stand that the jury is permitted to receive evidence regarding the case, and no juror is permitted to communicate to any other juror anything he may have heard regarding the case from any source other than the witness stand. In deliberating on this case, you are not to refer to or discuss any matter or issue not in evidence before you, and you are not to talk about this case to anyone not of your jury. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given to the testimony. But you are bound to receive and to follow the law from the court. After you have retired to consider the verdict, no one has any authority to communicate with you except the bailiff who has you in charge. You may communicate with the court in writing, signed by your presiding juror, through the bailiff who has you in charge. Do not attempt to talk to the bailiff, the attorneys, or the court concerning any questions you may have. After argument of counsel, you will retire and select one of your members as your presiding juror. It is the duty of your presiding juror to preside at your deliberations and to vote with you in arriving at a verdict. Your verdict must be unanimous, and after you have arrived at your verdict, you may use one of the attached forms by having your presiding juror sign a particular form that conforms to your verdict. And it is signed by me, Judge Raquel Rocky Jones, presiding judge of 203rd Judicial District Court, Dallas County, Texas. And you will see on the back page there are 3 verdict forms. There are 3 forms. The very first verdict form says, "We, the jury, unanimously find the defendant guilty of capital murder as charged in the indictment." It is a signature line for the presiding juror and then a line for the presiding juror to print their name. Or the next verdict form. "We, the jury, unanimously find the defendant guilty of theft as included in the indictment." A signature line for the presiding juror and a printed line for the presiding juror to print their name. Or there's a verdict form that states, "We, the jury, unanimously find the defendant not guilty." There is a line for the presiding juror to use their signature, and then there is a line for the presiding juror to print their name. State, are you ready for closing argument?